Dear students, I welcome all of you to today's lecture on different types of companies under the Indian Companies Act of 2013. The main aim of this lecture is to develop an in-depth understanding of different types of companies, the various facets and conditions necessary for the formation of different types of companies that can be established under the Indian Companies Act of 2013. After going through this lecture, you should be able to A. Know about the various types of companies under the Companies Act of 2013, understand the various requirements needed by different companies under the Indian law. Dear students, in this part of the lecture, we will try to enhance our understanding of companies by extensively looking at different types of companies recognized under the Companies Act of 2013. This will be elaborated by the guidelines and the structure drawn by the company law necessary for the recognition of any company in India. The Companies Act 2013 passed by the Parliament has received the assent of the President of India on 29th August 2013. The Act consolidates and amends the law relating to the companies. The Companies Act 2013 has been notified in the Official Gazette on 30th August 2013. Some of the provisions of the Act have been implemented by a notification published on 12 September 2013. The provisions of the Companies Act 1956 are still in force. Now let's move to the different type of the companies. Types of companies can be categorized on the following basis: on the basis of the mode of incorporation, on the basis of number of members, on the basis of control, on the basis of ownership, and finally on the basis of nationality. Now let's move to the first type of categorization, that is categorized on the basis of mode of incorporation. Firstly comes the statutory company. These companies are constituted by a special act of Parliament or the state legislature. These companies are formed mainly with an intention to provide the public services. Examples of these companies are the Reserve Bank of India, Life Insurance Corporation of India, etc. An important aspect of such type of companies is that they draw the powers from the acts which constitute them, and any changes in the company can only be done by the legislative amendments. Further, they do not have any memorandum or articles of association. Another company which comes under the mode of incorporation is the registered company. Registered companies are registered under the Companies Act of 2013 or under the previous company law are called registered companies. Such companies come into the existence when they are registered under the Companies Act and a certificate of incorporation is granted to it by the registrar. Registered companies can be further categorized into three categories based on the company liability via company limited by shares, company limited by guarantee, and unlimited company. Before moving on to the categorization, let's first understand the concept of liability. What it means by a liability of a company. When a company is incorporated under the Companies Act, it can either be incorporated as a limited or unlimited company. The difference between the two is in the burden of the company's liability on the members or owners in the event of debt or losses. In a limited company, the liability of the members is limited to the shares they hold. However, in an unlimited company, there is typically no share capital, and the members or owners or the directors of the company are personally liable for the debts of the company. Now that we have an understanding of the concept of liability, let's move on to the company limited by shares. Most commercial or for-profit organizations usually follow such a type of structure. The company receives its funding from the contribution of the members that in turn constitutes the share capital of the company. The liability of each member is dependent upon the extent of the value of the number of shares he or she has. Companies like Facebook, Reliance, Infosys, and Tata are some of the examples of companies limited by shares. These types of companies are the most popular in India due to the ease of the business they bring. Then comes companies limited by guarantee. These companies are exact opposite of the companies limited by the shares. Most non-profit organizations and charitable societies follow this pattern, as the owners don't seek to gain money from the operations of the company. The profits earned in such companies are retained and redirected for the operation of the company or invested elsewhere. Such companies may or may not have a share capital, but in most cases, companies limited by guarantee have no shareholders or share capital. These companies usually receive their initial funding through government grants, endowments, subscriptions, donations, etc., which removes the reason for allotting the shares of the company. And lastly, we move to the unlimited company. As per the Section 2, subsection 92 of the Act, a company has no limitation on the liability of its members in an unlimited company. Section 3, subsection 2C of the Companies Act 2013 allows a company to be formed as an unlimited company. Hence, members or the partners are required to meet the needs of the company in varied aspects or debts without any limit over their liability at the time of liquidation. They are liable to cover its debts fully. Therefore, the personal property of the members, partners and directors can be used for recovering the debts of the company. The next type of categorization is on the basis of numbers. On the basis of numbers, a company can be divided into either public or a private company. Now, what does it mean to be a public company? As the name suggests, a public company is a company where the shares are traded on the stock exchange and the fund is raised by the public. This is one of the key differences between the two types of companies. The Section 3, subsection 1 of the Companies Act 2013 says, public company can be formed for any lawful purposes by 7 or more persons. There is no limitation on the maximum number of members. However, the minimum should be 7. Further, the Companies Act says under the Section 149 subsection 1 that public companies should have a minimum of 3 directors on its board. Also, the name of the company should be accompanied by the word limited at its end, as is mentioned by the Section 4 of the subsection 1 of the Companies Act 2013. Now that we have discussed what a public company is, let's try to have an understanding about the private company. Defined under the Section 268 of the CA Act 2013, a private company means a company which by its articles A. restricts the right to transfer its shares, B. limits the number of members to 200. Section 3(1) of the CA Act mentions that the private company may be formed for lawful purposes by 2 or more persons. Further, Section 149(1) of the CA Act details that every private company shall have minimum 2 directors in its board, and Section 4(1)(a) of the CA Act lays down the condition that private company is required to add the words private limited at the end of its name. Further, private companies can also be categorized into small company and one-person company. Now let's move on to small company. Section 285 provides for small companies under the Act of 2013. This new form of private company has been classified as a small company based on its paid-up capital and the turnover. A company will be said to be a small company if its paid-up capital share does not exceed rupees 50 lakhs with a maximum ceiling of rupees 10 crores, or if its turnover does not exceed rupees 2 crores with a maximum ceiling of rupees 100 crores. However, a holding or a subsidiary company, a company registered under Section 8 or a company governed by a special act shall not be considered as a small company. Now that the small companies have been discussed, what are one-person companies? With the enactment of the Companies Act 2013, several new concepts were introduced that were not in the existence of the earlier Companies Act, like the 1956. These completely revolutionized the corporate laws in India. One of such was the introduction of one-person company concept. This led to the avenue for starting businesses giving flexibility which a company form of entity can offer, while also offering limited liability that sole proprietorship or partnership does not offer. Defined under Section 2, subsection 62 of the CA Act 2013, One-person company means a company which only has one person as a member. The Act says such type of company shall have minimum one director in its board. Its sole member can also be the director of such company. With the introduction of the concept of one-person company, small businesses can now be corporatized. In the one-person company, the legal as well as the financial liability is limited to the company alone. The conversion of one-person company into a company under the Section 8 of the Act has been barred by the companies, which are governed by the rules of 2014. Now, dear students, let's move to the categorization on the basis of control. On the basis of control, there is one, the holding company. According to the Indian company law, a subsidiary is a firm that is owned and controlled by another company, whereas the latter is referred to as a holding company. As a result, the term control is defined by the company law to determine whether a firm qualifies to be considered as a holding company or not. Management or share ownership can be both used to exert control. According to Section 4, subsection, a company is deemed to be the holding company of another if but only if that other is its subsidiary. The other company in such case is known as a subsidiary company. A holding company's connection with subsidiary company is similar to that of a parent and a child. Following conditions are set under the Companies Act of 2013 for the fulfillment of a holding company. These are: holding company should own more than 50% of other company's stock or capital, holding more than 50% of the voting rights, and as such controlling to appoint or remove the board members and the directors. Even though the holding company has the majority management control over the subsidiary company, however, the holding company doesn't interfere with the day-to-day activities of the latter company. The second company is the subsidiary company. A company is known as a subsidiary of another company when its control is exercised by the latter, that is the holding company, over the former called as the subsidiary company. You can form a subsidiary for a certain brand under your main company, or you can construct a firm that invests in one or more other companies, while holding enough financial interest to be considered a controlling party. Then comes the categorization on the basis of ownership or nationality. On the basis of ownership, companies can be divided into governmental and foreign companies. Government companies are those types of companies in which 51% or more of the paid up share capital is held either by the central government or the state government, or partly by the central government and partly by the state government. Such types of companies are called government companies under the Section 2, subsection 45 of the Act of 2013. It is to be noted that any subsidiary of a government company shall also fall under the classification of a government company. However, a government company is neither a government establishment nor is a government department, irrespective of the fact that major paid up share capital is held by the government. The companies incorporated under the Companies Act have a corporate legal personality that is distinct from that of the Government of India, and the government only owns the share capital. The rest of the other things like the land and the buildings are owned by the company itself. A government company may also wind up like the other companies under the Act. Now that we have understanding of government companies, let's move to the foreign companies. A foreign company is one which is incorporated outside India but has a place of business in India. For example, Philips, LG, etc. Under the Companies Act of 2013, a foreign company means any company or body corporate incorporated outside India which has a place of business in India, either of its own or if it conducts business through an agent, physically or electronically or in any other manner. However, all foreign companies are not required to comply with the Companies Act. It is only applicable to foreign companies where 50% or more of the paid up share capital calculated by including preference shares, is held by the Indian entities. Foreign companies must comply with the provisions of the Companies Act of 2013 in respect to the business as if it were incorporated in India. Dear students, till now we have covered the major categorizations of companies under the Companies Act of 2013. However, the Act also gives space to companies of a special nature with a specific scope. Let's have a look at some of those companies. Number 1, producer companies. We can try to understand a producer company as being legally recognized body of farmers, agriculturists that is formed with the aim of raising or bettering the standard of living of the farmers and at the same time ensure economic support in terms of profits, incomes and support as well. The Companies Act of 2013 has allowed primary producers to organize themselves to gain a maximum profit from the market-oriented economy. A producer company is a hybrid between a private limited company and a cooperative society. It combines the goodness of cooperative enterprise and the vibrancy and efficiency of a company. It works with unique elements of cooperative business while enjoying the structure of a private limited company. As per the Act, the objectives of a producer company should relate to all or any of the following matters. Number A, production, harvesting, procurement, grading, pooling, handling, marketing and selling, export of primary production of the members or import of goods or services for their benefit, provided that the producer company may carry on any of the activities specified in this clause either by itself or through other institution. B, processing including preserving, drying, distilling, brewing, vinting, canning and packaging of the produce of its members. C, manufacture, sale or supply of machinery, equipment or consumables mainly to its members. D, providing education on the mutual assistance principles to its members and others. E, rendering technical services, consultancy services, training and research development and all other activities for the promotion of the interest of its members. F, generation, transmission and distribution of power, revitalization of land and water resources, their use, conservation and communication relatable to primary produce. G, insurance of producers or their primary produce. H, promoting techniques of mutuality and mutual assistance. I, welfare measures or facilities for the benefit of members as may be decided by the board. J, any other activity, ancillary or incidental to any of these activities referred into the clause A to I or other activities which may promote the principles of mutuality and mutual assistance among the members or in any other manner. Financing of procurement, processing, marketing or any other activities specified in clauses A to J which include extending of credit facilities or any other financial services to its members. Another type of special companies are called Nidhi companies. Nidhi companies are recognized under the section 406 of the Companies Act. A Nidhi company is a type of company in the Indian non-banking finance sector. Nidhi is a company which has been incorporated as a Nidhi with the object of cultivating the habit of thrift and saving among its members, receiving deposits from and lending to its members only for their mutual benefit. It works on the principle of mutual benefits that are regulated by the Ministry of Corporate Affairs. However, since these Nidhis deal with their shareholder members, only RBI has been exempted from the core provisions of the RBI Act and other directions applicable to the NBFCs. Nidhi companies existed even prior to the existence of the Companies Act 2013. The basic concept of Nidhi is principle of mutuality. These companies are more popular in South India and 80% of Nidhi companies are located in Tamil Nadu. Lastly comes the dormant companies. The concept of a dormant company was not explicitly defined under the Companies Act 1956 and was introduced under the Companies Act of 2013. Under the provisions of the Act, it is a company that is registered under the Act but not carrying any significant business or financial transitions. In common parlance, the word dormant means inactive or inoperative. A dormant company is an excellent opportunity to start a company for a future project or hold an asset, intellectual property without having significant accounting transactions. On the other hand, if a company has not filed its annual returns for 2 consecutive years, then such a company will also be called as a dormant company. The Act specifies that a dormant company is one that has no significant business operations or accounting transaction, is formed to hold an asset or intellectual property, is formed for a future project. The first question that most people ask is that why incorporate a company only to get a dormant status for it? The primary reason for securing the status of a dormant company is to ensure that the company continues to remain a legal entity despite not carrying out business activities. Here are a few benefits of getting the dormant status. Retaining the company name. The unique name of the company can be retained along with other intellectual property assets that the company holds, such as trademarks. The dormant status will ensure that others can't trade under this name and the name remains protected. For a future project, this could signify the intention of a company to start a business, but has chosen to remain dormant to wait for the completion of other formalities. For instance, a company can be created to buy a land or property for running its business, but can remain dormant until other formalities are complete. With this, we wrap our today's lecture. Dear students, I hope you enjoyed this lecture and have developed a wholesome understanding of companies, their definition, characteristics, and different types of companies established under the company law and recognized by the Companies Act of 2013. I wish all of you good luck.